Hi and welcome to We Listen, India's first podcast channel on insolvency law. In this week's podcast, let us discuss an interesting case where the adjudicating authority made critical comments on the so-called commercial wisdom of the Committee of Creditors. It emphasized that the COC has not at all applied its mind and that there was no element of wisdom displayed, leave alone the commercial wisdom. Having said so, it rejected the decision of the COC to liquidate the corporate debtor and approved the resolution plan which was originally rejected by the COC. I'm not sure if it surprised you, but it did surprise me to a very large extent. But how in the world can this happen? Come on, let's find this out together. One of the financial creditors initiated CARP under Section 7 of the Code against Ushdev International Limited, the corporate debtor in this case, which was admitted by the Mumbai bench of the NCLT. Upon issuance of the expression of interest, only one applicant, that is Taguda Pte Limited from Singapore, had qualified to submit the resolution plan. After various negotiations with the COC, the resolution applicant modified its resolution plan as per the suitability of the COC, and the COC had sought some time to consider the resolution plan. However, at its meeting held on February 2, 2019, the resolution plan submitted by Taguda was rejected and the COC voted to liquidate the corporate debtor. Let us dig deeper into the facts of the case. Well, the average liquidation value as per the valuation reports of the registered valuers is approximately Rs 67 crore, whereas the upfront payment offered by the resolution applicant Taguda is 200 crore. Even where the upfront payment itself is much higher than the liquidation value, why did the COC reject such plan? Right? The only thread which can lead us to find an answer to this is the receivables. As per the books of the corporate debtor, the receivables stand at 75 crore, while as per the assessment made by SBI from an undisclosed recovery agency, the recoverable amount from the debtor is around 400 to 500 crores. An interesting fact in this regard is that the registered valuer itself has stated in its report that most of the debtors of the corporate debtor are under liquidation proceedings or NPS themselves, and that most of the receivables are outstanding for more than 3 years, and stating this reason it has assigned nil value to majority of the sundry debts due to the corporate debtor. So on one hand, we have an argument that the resolution plan shall be approved since liquidation won't fetch much to the COC as the debtors are themselves in stress and that it would gravely prejudice the livelihood of the employees of the corporate debtor. And on the other hand, the State Bank of India argues that the COC need not justify its decision taken in commercial wisdom as the same is given a paramount status without any judicial intervention. Given this, the resolution professional filed an application under Section 33 of the Code seeking an order for liquidation of the corporate debtor. Now let's get to know how the NCLT had handled this issue. The adjudicating authority analyzed the status of receivables and observed that the SBI had completely ignored the facts and figures reflected in the audited accounts of the corporate debtor while contending that the recovery from receivables is approximately Rs 400 crore. Also, the adjudicating authority opined that in the case in hand, the two important preconditions of commercial wisdom, that is, existence of prudence and existence of commercial data, are missing, and absence of commercial wisdom makes such decision of the COC to liquidate the corporate debtor a bad decision not sustainable in the eyes of law. Further, relying on the findings in the Mafatlal judgment, the adjudicating authority led to a conclusion that if the process which is prescribed by law is not followed for approving a resolution plan, as in this case, then the adjudicating authority has the authority to pierce the wheel and is expected to judiciously x-ray the plan. The adjudicating authority went on to observe that in the present case, the procedure established by law is that the commercial wisdom is to be exercised by the COC, and if the same is not done, then the adjudicating authority within its jurisdiction can neglect such an illogical, unreasoned, unfounded and unsound decision of the COC. The adjudicating authority also observed that under supervisory jurisdiction, the job of the adjudicating authority is not merely a stamping authority to approve each and every decision of the COC, but to test decision on 3 parameters. Number 1, the feasibility of the plan. Number 2, the viability. And number 3, the effective implementation thereof. After due examination of the plan, the adjudicating authority approved the same and had set aside the decision made by the COC to liquidate the corporate debtor. A resolution plan which is otherwise fit to be approved but on some flimsy ground rejected is nothing but contravention of provision of law, is what the adjudicating authority had observed. The Honorable Judicial Member in the order stated that my reason and conscience do not allow me to let this company go into liquidation when such a better beneficial offer is already on the table. Accordingly, the Adjudicating Authority approved the resolution plan by its order dated November 7, 2019. Wait there. The story didn't end here. The SBI preferred an appeal against this order before the NCLAT on the ground that it is in disregard of the decision rendered by the Honorable Supreme Court in the case of K. Ushdev vs. Indian Overseas Bank and others. The Honorable NCLAT, via its order dated November 29, 2019, has stayed the order of the Adjudicating Authority and directed the resolution professional to manage the affairs of the company and continue to discharge his functions as before. As on today, the matter is still pending before the NCLAT and the interim orders are still in force. Let us wait and see how the NCLAT deals with this case. Thanks for listening to We Listen. If we listen, we learn.